Good morning, everyone. Thank you for making time to listen to us talk. I'm Jonathan Edwards. Colleague is Sophia Rogers. We're both barristers at Radcliffe Chambers. I'm going to be talking to you first of all about some probate litigation procedural issues that can arise. And after that, Sophia is going to liven things up with a talk on undue influence and fraudulent calumny, which are two things alleged every day, but proved not very often, but always popular with those who have been left out of wills, which they feel they ought to have been included in a big way. Right, so without any further introduction, I'll now get started with. So the way I'm going to be approaching this is more or less through the timeline of a typical case. So I'm going to start off with pre-action procedural moves, in particular the ever popular caveat, and pre-action disclosure, what the approach should be to that. Moving on to when proceedings have begun, the possibilities for non-party disclosure, which I think is an overlooked subject in probate cases. Then dealing with testamentary documents, which are after all what the case is about. Then another point which can be easily overlooked, but can cause immense misery if you do, which is making sure the decision of the court is binding on every party who needs to be bound, because the last thing you want to do is fight your probate case twice. And lastly, I'm going to talk about ways of ending probate proceedings without a full trial. Obviously, what someone who doesn't practice in this area might imagine is that proceedings end with a trial with barristers robed and wigged before a judge and everyone having their say and the judge deciding which will or none is right. But the vast majority of cases, as I think everyone here will know, don't end that way. Sometimes it can be very simple to wrap things up, other times not so much. So I'm going to be talking a bit about the ways you can do that. By way of a preliminary point, I think probably this is old news to everyone here, but sometimes worth reminding that it's only a tiny fraction of estates of all the people who die in the country each year who need probate proceedings of any kind. Most of the time, the estate can be administered without lawyers at all. Even where a grant to probate is required, or a grant of letters of administration, the vast majority are obtained without incident under the non-contentious probate rules, just by applying to the probate registry for a grant, which is easily done, and it's about to get easier because there's about to be an online portal coming in. And if that happens, what you end up with is a grant in common form, which is perfectly good for all the purposes that you need a grant for. Its disadvantage is that it's not completely final. It is possible for someone to apply for it to be revoked on the basis that it doesn't represent the deceased's true final will or absence of any will. But most of the time, grant in common form is perfectly good. So that's what I'm going to be talking about when I mean a grant in common form, the kind of grant you get from the probate registry. However, the other option, and this is usually the case if there's a determination at a trial, although actually it is possible to have it even without a full trial. The result is that the court will decide whether each will that's been brought into question is valid or not valid, and will end up issuing a grant in solemn form. And a grant in solemn form can't just be revoked in the way that a grant in common form can be. It's not necessarily the last word. If someone who's not bound by the proceedings were to commence their own probate claim, it might be possible for it to be revoked. It's very unusual, but that's part of why it's so important to make sure everyone is bound by the decision. It's a much more elaborate process than seeking a grant in common form, unless everyone is agreed, which they never are if you're bringing probate proceedings in this way. These kind of proceedings aren't brought in the probate registry. They must start in the Chancery Division, and there's a whole part of the civil procedure rules devoted to them. It's got a practice direction too. As I may mention, if grant's already been made, that's not necessarily the end of the line. It's still possible for there to be a dispute, but in that case, the person disputing will need to seek revocation of the existing grant. So that's the overall landscape of probate proceedings. Before you get started, and something that anyone who practices in this area will come across pretty much straight away, is a caveat. And what a caveat does is it prevents someone getting a grant of probate in common form from the probate registry, and it's very cheap. I did try and look up before this talk exactly how much it costs. I found conflicting answers, but it looks like it's either £3 or £20, so pretty good value, one might think. And that is how almost any probate dispute is going to begin. Because what you want to do, if you don't like the apparent last will, or if you're concerned that someone else is going to get a grant you disagree with, you can stop them. Just like this, you don't have to give any reasons. You can just get a caveat, and they will not be able to get a grant of probate in common form, which is the easy way. What it doesn't do is stop anyone commencing proceedings in Chancery Division for grant in solemn form. It doesn't do anything whatsoever to stop that. It is nonetheless very annoying if you're hoping to get a grant quickly and easily, because it will stop you doing that. The main purpose of them is to prevent the grant being obtained quickly and easily, and to preserve the situation with no grant being made while the merits of any potential dispute are being investigated, because that can take time. You need to look into medical records if there's a testamentary capacity dispute. You need to consider the case very carefully if you're going to be alleging undue influence, and all the other things that it's desirable to do before you embark on what can be very costly proceedings. That's the main purpose of them. And for that reason, I think they last in the first instance for 6 months to give you time to do that. But you can renew them, and that's very easy as well. The only thing that can stop you renewing, apart from probate proceedings in the Chancery Division, is if someone produces what's called a warning. That again is very easy. That's a very simple step. Once there's a warning, the person whose caveat it is can either just let the caveat go, or if they don't want to do that, they can enter an appearance. And this is again a simple step, but it does require some reasons to be given why the person who has the caveat has an interest which is contrary to the person who gave the warning. So they've got to say something like, the apparent last will is invalid because it was procured by undue influence. I'm the beneficiary under the previous will, something like that. Once that's happened, they become permanent in the sense that they don't need renewing anymore, but they can still be got rid of, and I'll come on to that in a moment. I've talked about the primary purpose of caveats. However, they're also extremely popular for parties who don't really intend to challenge the will at all in the probate sense, but do intend to challenge it in the sense of bringing a claim under the 1975 Act on the basis that the provision the will makes for them, although it's a valid will, isn't reasonable provision. That's perfectly fine. There's nothing stopping you doing that. It's not really what the caveat procedure is for, because a claim under the 1975 Act isn't a probate dispute, strictly speaking. And for that reason, if someone writes to your client saying, doesn't look like you're challenging the will, we want to get a grant of probate, please remove your caveat so that we can do that in common form, then it's not very sensible to refuse that request. What you should do instead is allow the caveat to go, allow the grant to be obtained, and get on with bringing your 1975 Act claim if you're going to. And if you don't, what is likely to happen is that someone will try to remove the caveat because you don't have a good reason for having it. Whether or not you're able to give a reason for having it, the party who's interested in the estate can apply to the court, and it's in cases in the southeast, this will usually be in the Principal Registry of the Family Division on High Holborn. And what they apply for is an order discharging the caveat. So even though it's become permanent and doesn't need to be renewed, the court can still get rid of it. You need written evidence to explain the basis of it. This has always needed to be in affidavit form, but the rules are about to be amended, and soon a witness statement will be sufficient. That's the main amendment in the 2020 rules. The rules will also now include an overriding objective, so you can be reassured that now the rules will have the objective of deciding cases justly, and if you're really lucky, maybe even expeditiously. What are you going to put in your written evidence? The gist of it will usually be that they've had enough time to investigating, and so the caveator needs to either bring proceedings challenging the will that would otherwise have a grant obtained for it, or else give up and allow the probate to be obtained. As a rule of thumb, something that was handed down to me by one of my pupil masters and has always served me well, that argument is likely to succeed once about a year has passed since the caveator became aware of the death of the deceased, which will usually be more or less immediately after deceased death, although not always. I think that's just felt to be long enough that you should have been in a position to issue your probate claim if you were going to. That might not work if there's been some impediment to investigating the position. And arguments about whether the person who would be entitled, who has the apparent last will, has been difficult in pre-action correspondence might be such a reason. What normally happens is that if a fairly lengthy period has elapsed, say around a year or more, the typical form of order, I've never seen the court make an order in different form, I've done a handful of these, is a kind of unless order, giving the caveator a period of time to issue a claim in the Chancery Division. And typically, because the caveator will be the person who doesn't want the apparent last will to be admitted to probate, their claim will usually be to propound against the last will, possibly earlier wills as well, and seek a grant in solemn form, either of a will under which they benefit, presumably, or a grant of lesser administration. That's the usual form of order. And typically it's also included in that if the caveator does bring those proceedings, the costs of this procedure, the summons, become costs of that probate claim. And therefore, whoever wins the probate claim is likely to get their costs of the summons to remove the caveat. That might not happen if you've tried to take this step too prematurely. And I would be particularly wary of trying it within 6 months of the caveat, because the default position is that a caveat lasts for 6 months in the first instance. So I think you've got a hard task on your hands if you want to persuade the court that it needs to be got rid of before then, because the rules rather assume that that's an appropriate length of time for the caveat to be in place. If you really do want to get a move on and you're unhappy with the caveat, you do always have the option of bringing proceedings in the Chancery Division, either for a grant in solemn form to deal with the whole dispute, or if there's something that needs doing with the estate, a more limited grant to allow you to do that. Less frequently encountered than caveats, I tend to find, is the citation procedure. And this is, so a caveat stops a grant being obtained. The gist of the citation procedure is it's to require someone to take an active step, or if they don't, something else will happen. And the main situations it's for is if it's a person who's entitled to the grant, say the named executor in the apparent last will, delays in doing that, then, for instance, a beneficiary under the will, who might be one of the other people entitled to a grant if the executor doesn't seek a grant, can use this procedure to require the named executor either to accept a grant or refuse it. And then if they don't respond to this, their right is cleared away, and the next person entitled can then go ahead and obtain a grant in common form instead, because the person in priority has been taken out of the picture. Slightly related version, if, for instance, you've got a named executor who's intermeddled, they're not supposed to have the option of not taking the grant. They can be forced to take it. And so the citation procedure also allows you to require a person to show cause why that ought not to happen. And lastly, possibly an underused procedure. The executors and beneficiaries of an apparent will. So suppose you've got a will that's 2017 and your client is the beneficiary under an earlier will of 2014, but thinks the 2017 will is invalid. But the beneficiaries and executors of the 2017 will are not getting a move on. What you can do is use this procedure to require them to try and propound the 2017 will. And if they don't respond, then you instead can seek for a grant in common form of the 2014 will as if the 2017 will were invalid. Because you're skipping past an apparently valid will, you do need to cite the executor and all the beneficiaries of it for fairly obvious reasons. I think that procedural route should perhaps get more use than it does. On the other hand, it's very easy for someone to respond, but at least you get the proceedings moving. So I wouldn't get your hopes up for disposing of a real dispute this way, but it might be a way of getting the dispute to progress. For this procedure, you need personal service, so that's a downside of it. The court can order otherwise, and it might do that if, for instance, a named beneficiary under the will can't be found, but the court's going to need persuading of that. Another point is, if the person wishing to use this procedure has the will, they've got to lodge it with the court. I've already touched on pre-action disclosure. The usual expectations apply. If you've got relevant documents that the other side are going to need to understand their case, particularly if they're going to be disclosable in due course, if you have proceedings, you ought really to be disclosing them. I know that clients are quite often reluctant to do this. However, refusing to do it does, I think, just tend to entrench any suspicions that the other party already has, because they'll think, well, if this disclosure is normal, and if they're refusing to give it, there must be something they want to hide. So that's a quite common chain of reasoning. And also clients need to understand that if the other party is provoked into actually bringing the probate claim, if they don't give up, then the documents are likely to be disclosable anyway. Another disadvantage is if you don't disclose the documents, it might be taken into account on costs, because it's well established that a party might not suffer the consequences of the usual costs rule if there were some reasonable grounds to investigate the validity of the will. Relatedly, refusal to give pre-action disclosure might be a reason why a person who has a caveat is justified in not letting their caveat be removed, because they've been hindered in investigating. And I have seen it happen that the order discharging the caveat, although it was still made on an unless basis, time only started to run from when various documents have been provided. What I haven't seen, and I don't see in the reported cases, is applications for pre-action disclosure, formal applications to the court for pre-action disclosure. I can't see any reason why in principle that shouldn't be possible, but people don't seem to do them for whatever reason. And I suppose with any application for pre-action disclosure, you've got to ask yourself whether it's really an efficient use of resources, or whether you are going to bring the claim anyway, and you already have enough material to do that. Once proceedings have begun, you might also look at non-party disclosure. Non-party disclosure before proceedings have begun is going to be extremely difficult. You're not going to be able to make a Norwich Pharmacal application. It's not at all likely. You can make a Larkin-Nugas statement, and it's expected that professional solicitor or will writer will respond, but there's no actual obligation on them to do so. So you can't really enforce it unless you wanted to use some of the specific procedures, which I'll come on to later. But you can bring an application for non-party disclosure in the usual way once litigation has begun. And I mentioned a recent example of this, which is the case of Gardner and Tabet. And disclosure was ordered against non-parties And interestingly, they weren't professionals. You might think that professionals involved in the will production process are especially likely to have orders for disclosure made against them. Perhaps the reason we don't see it is because professionals wisely provide the disclosure voluntarily. In this case, I've just outlined the categories of documents that were ordered. And interestingly, it included correspondence between the beneficiary of the will and the respondents, that's the non-parties who were involved in the will production process from around the time the will was made. So it's not just the obvious documents, the testamentary documents themselves can be more wide-ranging. Another interesting category was just documents bearing the deceased signature. The reason for that was for signature analysis, because having more examples helps the expert make a more reliable determination. Another early step in any probate proceedings is a mandatory one, which is lodging testamentary documents with the court. And I think it's often not observed that that does mean original documents, not just photocopies of them. And there's some specific detail in the Chancery Guide about what you need to do to make sure that your original documents don't get lost or destroyed, or hopefully not. The definition of these documents mainly includes will, draft of wills, written instructions for wills. Those are the core categories. However, if you're dealing with a will where the original will can't be found, then there's a wider category, and that's any document purporting to be evidence of the contents or a copy of the will. That could be a very wide document, because you might, for instance, have a letter, might not even be written by the deceased. You might have a letter from a family member complaining to another family member saying, Dad mentioned that he made a will in your favor. This is really unfair. I think you've been unduly influencing, something like that. And that would then be evidence of what the will was. Not necessarily conclusive evidence, but in my view, it would come within this category. One might not think it's very important to have the originals of such letters, but that's what the rule provides. These documents must actually be lodged. And going with this, there's an obligation to do a witness statement. There's a standard form for this in the practice direction, and that extends not only to documents in your possession and control, but documents of which you have knowledge. What about documents that you don't have? This goes back to something I was saying about non-party disclosure. There are some specific provisions under the Senior Courts Act for applications to the court, whether or not a probate claim is on foot, which can deal with this. You can apply to have a person brought in for cross-examination, or you can apply for them to produce a document. And producing a document might be particularly useful so that you can use the citation procedure I was mentioning earlier, because if you've got the will, you're supposed to lodge it. So having the will is handy. These don't seem to be used very often, but they are used sometimes, and they could be useful, particularly where you've got a non-cooperative non-party. For instance, a solicitor who drafted and witnessed the will, but has refused to give a Larkin Nugas statement. Unusual, but it could happen. The next topic I want to address is making sure that claims are binding. Particularly if you're the defendant, you might find that the claimants brought the claim, but without naming as parties all the people who might be affected by the dispute. And the risk of that is that if the dispute reaches a final conclusion, someone who's not a party, but is unhappy with how it went, might bring their own probate claim, and they won't necessarily be stopped from doing that. How do you deal with this problem? One way would just be to apply to join them as parties, but there's a simpler way, which doesn't necessarily involve them becoming parties. That's the rule 19.8a of the CPR. You can ask the court to make an order that the non-party be notified. There are various things you've got to do to notify them, spelled out in the rule. And then they have a choice. They can either acknowledge service, become a party, and have to do all things that a party does, like lodge testamentary documents, make a witness statement about that, file a defense or whatever statement of case is appropriate, and all the other steps in the litigation. Or I suppose they could acknowledge service saying they won't dispute. Never seen that happen because they might as well not respond at all. If they don't respond by acknowledging service, then they will be bound by any judgment given in the claim as if they were a party. So then there usually will be res judicata. They'll be bound and they'll be prevented from relitigating it in the future. Because if someone acknowledges service under this rule, they have to do all the normal steps starting from the beginning. You want to consider this really early on, because the last thing you want to do is reach the PTR and then realize that you want to do this. And then they might acknowledge service, and for that party at least, the proceedings almost begin again. They have to do disclosure, witness statements, etc., etc. Can be a disastrous delay. So you don't want that. You want to deal with it really early on, certainly in advance of the first CMC. The rules do actually say you're supposed to make a formal application supported by evidence. I've tended to find you can get away with just raising it in a draft order and a skeleton argument in advance of the CMC, but strictly speaking, you're supposed to apply. Coming towards the end, probate proceedings coming to an end without a full trial. Something client might not realize is that you can't just get off the train if you don't like where it seems to be going. Whereas most litigation can be discontinued without the court's approval, probate claims cannot. And similarly, although a Part 36 offer, when accepted, will normally automatically stay the proceedings, that will not happen with a probate claim. There's a good reason not to issue one of these claims unless you're sure you want to. However, the court can be persuaded to allow you to discontinue. And if everyone is in agreement about what should happen, it's quite often convenient to do that by just discontinuing the proceedings. So not pushing forward for a grant in solemn form and allowing the last apparently valid will to have a grant in common form instead. So the Chancery Division proceedings, they might have been transferred, but the proceedings that began in the Chancery Division will simply be discontinued, and whoever has the last apparently valid will can go to the probate registry for grant in common form. And you can implement the terms of your settlement with a binding deed between the executors and beneficiaries under that will to rejig the estate in accordance with your settlement. But this can often be a convenient way of doing it. One drawback of this, if you've gone to the trouble of notifying someone under Rule 19.8a, they're probably not going to be bound by this, even if they would have been bound by a judgment at trial. I've mentioned a case there which deals with abuse of process in the probate context generally. I think in that case, the person who was trying to relitigate was actually a party. They hadn't just been notified, but they'd been a non-responsive party. They hadn't done anything in the proceedings. So they were in a similar position, someone who's been notified under 19.8a. And the court didn't dismiss it out of hand. In fact, they weren't allowed to relitigate it, but you can't assume that will be the outcome, because how quickly they respond once they become aware of the settlement could be an important factor. So bear that in mind if you're planning to settle by discontinuing the proceedings. It might be that it's not convenient to get a grant in common form of the last apparently valid will. Could be all sorts of reasons for that. There might be something wrong with the will on its face, for instance. Another option is Section 49 of the Administration of Justice Act 1985. This allows for the court to approve compromises even where that involves pronouncing for or against the validity of wills. Drawback of this is that you need the consent of every relevant beneficiary. And that's any beneficiary under any will that you're going to be propounding for or against. And if the result of your compromise is going to be that there won't be an intestacy when there otherwise would be, you also need the intestacy beneficiaries. Of course, depending on, this can be a large number of people, and that if they can't be found, it might be inconvenient to do it this way. Or another problem might be they can't give consent, for instance, because they're a protected party. Or they can't give consent in a straightforward way. If, for whatever reason, you can't compromise using one of those routes, but there's no one any longer seeking actively to defend the claim, then I would suggest your default way forward is for it to be a trial on written evidence, which the rules provide for. Don't assume that's going to be a mere formality. The court is going to want to see the written evidence that backs up your case. So if you want to admit the will, you are going to need evidence from attesting witnesses, if they're alive and traceable, to show that it was duly executed. Because you are still, with trial and written evidence, seeking a grant in solemn form. So you do need to take it seriously. But it's obviously a lot less contentious than a full-blown probate dispute. Right, that brings me to the end. Hopefully I've left enough time for Sophia. I'll hand over to you now.
Okay, well, I'm going to be talking about contentious probate, undue influence and fraudulent calumny. And those are two, as Jonathan already said, they're two grounds on which usually the caveator can challenge the validity of the will. They're generally recognised, I think, as the hardest grounds to challenge the validity of a will, along with forgery. But in terms of the structure of my talk, I'm going to try and whiz through the core principles, because I assume that a lot of people watching will have already been familiar with these grounds. And I'm going to try to focus on some recent case updates. There's actually been quite a flurry of undue influence and fraudulent calumny cases recently. So I've just picked my favourites. And there's going to be a slide at the end that sets out a little list of some of the other cases if you wanted to go off and do your own research and have a read of those as well. So what are the core principles? Well, there's lots of cases that try to give definitions, or do give judicial definitions of undue influence in particular, but what I think is the best summary, it can be found in Re Edwards' Deceased from 2007, where Mr. Justice Lewison, as he was then, set out 9 different principles. So let's have a look at those. The first is that he says that in a case of a testamentary disposition of assets, unlike a lifetime disposition, there is no presumption of undue influence. And what this is a reference to is that, of course, we're all familiar with Royal Bank of Scotland and Ettrich and the idea of the Chancery definition of undue influence, that if there's a relationship of trust and confidence and a disposition that requires an explanation, then the court will sometimes presume the undue influence, and then it's for the undue influencer to rebut that presumption. Well, things are different in probate claims. Here you have to prove actual undue influence. 2, whether undue influence has procured the execution of a will is a question of fact. 3, the burden of proving it lies on the person who asserts it. And this next bit's important, and that's that it is not enough to prove that the facts are consistent with the hypothesis of undue influence. What must be shown is that the facts are inconsistent with any other hypothesis. In the modern law, this is perhaps no more than a reminder of the high burden, even on the civil standard, a claimant bears in proving undue influence as vitiating a testamentary disposition. Make sure I'm on the right slide. Next, he said that in this context, undue influence means influence exercised either by coercion, in the sense that the testator's will is being overborne, or by fraud. Coercion is pressure that overpowers the volition without convincing the testator's judgment. It's to be distinguished from mere persuasion, from appeals to ties of affection or pity for future destitution, all of which are legitimate. Pressure which causes a testator to succumb for the sake of a quiet life, if carried to an extent that it overbears their free judgment, discretion, or wishes, then that is enough to amount to coercion. He goes on and says the physical and mental strength of the testator are also relevant factors in determining how much pressure is necessary to overbear their will. For example, someone that's weak or particularly ill might be more susceptible to undue influence than someone that's fit and healthy. He also says that a drip approach might be highly effective in sapping a will. So when we think about coercion in an informal language sense, we often think of physical force and pressure being put on someone, but actually it can be much more subtle than that. And coercion can come in all different shapes and sizes. The next 2 points are with regards to fraudulent calumny. He says there is a separate ground for avoiding a testamentary disposition on the ground of fraud. The shorthand used to refer to this is fraudulent calumny. The basic idea is that if A poisons the testator's mind against B, who would otherwise be a natural beneficiary of the testator's bounty, by casting dishonest aspersions on his character, then the will is liable to be set aside. The essence of fraudulent calumny is that the person alleged to have been poisoning the testator's mind must either know that the aspersions are false or not care whether they are true or false. He said, in my judgment, if a person believes that he is telling the truth about a potential beneficiary, then even if what he tells the testator is objectively untrue, the will is not liable to be set aside on that ground alone. And he rounds up with Principle 9, saying that at the end of the day in these cases, what the court's really asking is whether in the making of the will, the testator acted as a free agent. The next case, that I think is quite important to remember when we look at core principles of undue influence is Schrader and Schrader, which came a little later. And in that, Mr. Justice Mann made this point. He said that it's a common feature of a large number of undue influence cases that there will be no direct evidence of the application of the influence. It is of the nature of undue influence that it goes on when no one's looking. So it usually happens behind closed doors. That does not stop it being proved. The proof has to come, if at all, from more circumstantial evidence. And this makes sense, because the star witness, the deceased who's been subjected to all of this pressure, is no longer with us, and they're unable to give evidence as to what went on. And often no one will have been around to give direct evidence of it. The three other points that I would just highlight as principles are these. The first is that in Re Edwards, you'll have noticed when we went through the slides, Mr. Justice Lewison said something along the lines that undue influence can be either coercion or fraud. And the master in the next case on the slide, Ria Maria, commented recently that that almost suggests that fraudulent calumny is a species of undue influence, and as to whether they really are two separate causes of action. This is quite an academic question. In my view, I think they are obviously two different causes of action, because undue influence is about coercion being enforced against someone such that they make a will that they wouldn't have otherwise made. So if you said to them, what are you doing? They would say, well, I'm making this will, it's not really what I want, but I must do it. Whereas fraudulent calumny is very different. It's where by making misrepresentations to the deceased, you poison their mind to such extent that they actually want to make this will, because you've turned their mind against a particular person that otherwise would be a beneficiary. Furthermore, at least aside from the academic question of what kind of cause of action is this, when you're pleading it and addressing it in a claim, you must plead them separately as two distinct causes of action. We're all familiar with Practice Direction 16, para 8.2, which provides that if you're going to allege fraud, you must do it specifically. And then there's an older case called White and White, which provided that you can't wrap it all up in an undue influence claim. If you're going to make a charge of fraud, then the plea of undue influence alone is insufficient to do that. The next point to note is, of course, these are two very serious allegations. So you're dealing with the standard of proof for fraud. It's the normal civil standard balance of probabilities, but there is a high degree of proof. In general terms, the way to think of it is the more serious the allegation you're making, the less likely it is that it happened, and therefore the more cogent the evidence you need to satisfy the court of your allegation. And finally, on the slide, I've just given a bit of a warning about costs. Because these are serious allegations, if your client makes them and is unsuccessful, it is usually most likely that they're going to be penalised in costs, and a costs order will be made against them. Of course, that isn't always the case, because, for example, if they challenge the will on lots of grounds, like capacity, knowledge and approval, and were successful on those, well, then there may be some form of, for example, issue-based costs order. But these are serious claims, so everyone needs to be aware of the cost risk before issuing. So that was a whistle-stop tour through the principles applicable to undue influence and fraudulent calumny. This is the first case that I was going to speak to you about. This is Marco and Christa Doulidis, which is, I think, my favourite fraudulent calumny claim. It's also the only claim that I'm going to talk about today that was successful on fraudulent calumny, so it's definitely worth a look. It's a case that two of the members of my chambers were in. I think Charles Holbeach was for one of the daughters, Nikki, and Kate Selway QC was for the other daughter, Andre. And here's what happened. The deceased had only the two daughters. She left her whole estate to her daughter, Nikki, and excluded Andre. Nikki sought to prove the will. Andre challenged on the ground of fraudulent calumny. And Nikki just denied having made any representations to Mum at all to poison her mind against Andre, or at least any that she didn't honestly believe, which we've covered as a defence. While it was a successful claim, the court found that the deceased's intention was always to ensure a roughly equal distribution of her estate between the daughters. Great attention was paid to the professional will draft as evidence, which reflected that. It was found that the deceased wrongly believed that excluding Andre would have allowed for a more even distribution of her assets, because Andre had helped herself to a substantial amount of assets already and that Nikki had not. And the judge found that that was a wrong belief. And where did it come from? He said, well, I think this is based or came from fraudulent misrepresentations that Nikki had made about Andre having either stolen or taken a large amount of the deceased's money, and that poisoned the deceased's mind against her. Now, this was quite a complicated factual judgment, and it's quite long, so it's a bit difficult for me to give a complete breakdown of all of the different evidence before the court. But one of the incidents that seemed to be most striking for the judge when it came to proving these fraudulent misrepresentations was that there was quite a bit of dispute between the sisters before Mum's death about where her money should be kept and how to protect it. And this centred around the fact that their dad had died, leaving Mum hundreds of thousands of euros across different bank accounts in England and also in Cyprus, in particular the Bank of Cyprus. And Mum was having difficulty accessing this money herself. So quite openly, Andre had moved the accounts into both her and her mum's joint names. And that meant that there needed to be both of their signatories on the account to remove money. And then what followed was quite a long chain of both documentary and other evidence showing that Nikki was very angry at the fact that Andre was a signatory on these accounts. And when we talk about poisoning the mind, well, the impression you get from this judgment is that Nikki was going around pouring poison everywhere. So she was making allegations against the bank, that the bank had been colluding with Andre to try and stop her mother getting hold of her money. She went along to the bank and took mother with her to air and discuss these allegations that she'd made against the bank. Ultimately, I think the bank removed them as customers and refused to deal with them anymore because it was so problematic. The judge found that Nikki had also taken Mum around the different banks in Cyprus, trying to withdraw money, knowing that they weren't going to be able to get it, almost to enforce this impression on Mum, and Mum becoming quite distressed that she wasn't able to get her money. In this case, there was also direct evidence from Andre of these representations having been given. So she says that she was present when Nikki had been telling her mum things like, all your money has gone into a black hole. What Nikki has done means that you'll never see your money again. And the judge found that during this heated conversation, the deceased had plainly obtained the impression that Andre had cheated her. Further, on top of that, Nikki, and this is quite common for undue influence cases, Nikki was managing all of the deceased's money in England. She was present at the giving instructions for the will. But what the judge really focused on was the fact that a materially inaccurate account of the deceased's assets had been given, such that the will drafter's advice about how to achieve an equal distribution between the sisters was given on a false basis. And Nikki, because she was there and she had control of all of the money, really it was for her to make sure the will draft had all the information. Mum also only spoke pidgin English. She was completely unsophisticated when it came to her financial affairs, and she'd been in poor health for a long period of time. So she was particularly susceptible to undue influence. The judge then went on to make some quite damning findings about Nikki. So he said she was a thoroughly dishonest and manipulative individual to whom integrity and truth are less important than achieving what she wants. He then cited 3 different examples of the evidence that had come out to show that she'd done previously dishonest things, such as swearing on oath to a different court, making applications with false statements, that kind of thing. He said she was a person who was wholly unable to restrain herself from forceful, intemperate, and manifestly untrue allegations. And this was all in his assessment of her as a witness at trial. On the other hand, he said the other daughter was a calm and sensible witness who dealt with all questions in a convincing fashion. So there's a few things that can be taken away from this case when we're thinking about what makes a successful fraudulent calumny claim. First, I think, is to always remember however strong you think your claim is going to be, a lot will come down on the date, how a judge assesses a witness. And you can see from the types of comments that he was making about the 2 daughters that he drew impressions through the live evidence as to their character, their likely dishonesty. And that seems to have informed whether he thought it was more likely or not that Nikki would have done the things alleged. He also made this comment, and that's that the representations in a calumny case are not made to the claimant and can almost never be pleaded with the same degree of precision or particularity as would be expected in a commercial fraud case. The representee is dead, and if the claim is made good, has gone to his or her grave with the poison having done its work. In this particular case, much has been learned as the evidence has emerged. And I think that really reflects the fact that there was quite a lot actually of direct evidence to prove the fraudulent calumny in this case. The next two cases that I'm going to talk about are called Nutter Nutter and Rhea and Rhea. They're two Chancery Master decisions. And the reason I'm going to look at them is they're really quite good comparisons to the case we've just looked at. So what happened in this one? Well, we had Mum, who left 3 children. Colin, one of the sons, under the most recent will, got the house, which happened to be the biggest asset, or only asset really, in the estate. The other siblings challenged the validity of the will on all grounds, apart from fraudulent calumny, and the Master said, no, it's unsuccessful. And for our purposes, we'll look at why undue influence was unsuccessful. Master Clark said that regrettably, in seeking to make out the ground, the claimants made a comprehensive attack on Colin's character and alleged that Colin had a dominating and domineering personality. And what's really striking from the judgment is they only really rely on a few specific alleged events that don't actually focus on the preparation and execution of the will. For example, they criticise how they thought he'd held court at the wakes of their parents, that he had an irrational obsession with how the family had treated Mum, that he'd carried out work for Mum but he'd charged for it, and some violent incidents between the brothers. And the Master found for each that either the allegation just wasn't made out on the evidence or that it was insufficient. For example, she said he wasn't actually irrational and Colin had not had anything to do with the preparation of the will anyway. Interestingly, at the end of the judgment, she records that counsel for the other siblings had said, well, what other possible reason could there be for this will? And that chimes with the limb of the Lewison test that you need to ask, well, is undue influence really the only hypothesis consistent with the making of this will? And Master Clark said, well, actually, no, there were loads of other explanations for why this will would have been made. For example, Colin lived with Mum, or at least very close to Mum towards the end of her life. He was her first port of call for help. He didn't have a house of his own, the others did. So this case is a good reminder that you really, when you're assessing the merits of an undue influence claim, you really need to look at whether there are other explanations to the will objectively. And sometimes clients aren't themselves prepared to look outside of the box, because as far as they're concerned, the only explanation that they can think of for why Mum would have written them out of the will was because of undue influence. Rhea and Rhea was quite similar on the facts, and in fact, Deputy Master Arkish refers back to Nutt and Nut and Master Clark's judgment a few times in this case. In this case, it was a daughter and 3 sons, and the last will left the house, which again was effectively the only asset in the estate, to daughter. And again, the sons challenged the will on all grounds, including fraudulent calumny. In this claim, there was even a clause in the will whereby the deceased had said why she was making the provision for the daughter. She says, well, daughter cared for me, sons didn't really help with my care, therefore I'm leaving everything to daughter. And it was found that it was right. The daughter had lived with Mum from 2009 until death. Many years later, she provided extensive care for Mum towards the end of her life, whereas the sons had only had limited involvement. And I think it was conceded towards the end of proceedings that actually that clause 11 was pretty much reflective of the situation at the time of the will. Daughter just denied having made any of the representations that were alleged, and she said, I haven't applied any pressure to Mum, and the judge regarded her as a reliable, honest witness. The interesting thing about this case is that the Master paid a lot of attention to the professional will drafters' evidence regarding the taking of instructions and execution of the will, and a lot of the judgment is actually dedicated to this. He says this will drafter had experience of about 16 years preparing wills and 10 years as a solicitor before that. The will file showed that she approached her task of taking instructions from the deceased and preparing the will with very great care and detail. And she was very clear in making the will that she would only take instructions from the deceased alone. And I've included this paragraph, which is one of the most flattering paragraphs I think a will drafter could hope for in a judgment. I'll just pick bits out of it. He said that she recognised that the will represented such a significant departure from a previous will that careful precautions needed to be taken to ensure that the deceased understood the implications and knew what she was doing. And she addressed those. She took steps to do that. For example, she followed this golden rule. She sent the deceased off to see a GP. That GP was then a witness to the will. He gave evidence in the proceedings and said, well, I understood the reason why I was witnessing the will was to make sure there was no pressure upon this lady. Deceased wanted her daughter to be in the room on the first meeting to give instructions, and the solicitor was very clear that she wouldn't hear from the daughter on any of it. And then she went on to meet the deceased twice alone to discuss the provisions of the will. The judge said that she ensured to her satisfaction that the deceased was acting of her own volition without any pressure being exerted on her by others. It's that if this level of care and confidence was applied in every case, there would doubtless be fewer disputes about wills coming before the courts. So that obviously weighed heavily in his mind in this case. With regards to undue influence, I should say both undue influence and fraudulent calumny were unsuccessful. Undue influence, similar to Nut and Nut, he said it's unfortunate that the defendants adopted the line of denigrating Rita, so they did a personal attack on her character, just like in Nut and Nut. And he said there's not evidence of Rita having exerted any coercion or pressure on Mrs. Rea to change her will. Their case is based purely on inference and supposition based on features of her personality. There is a wholesale lack of evidence which would point to facts consistent with the hypothesis of undue influence. Still less could it be said that the facts are inconsistent with any other hypothesis. And there's that point again from Rhea Edwards, that you have to focus on this hypothesis idea. He goes on and says a similar point about fraudulent calumny, and says just relying on inference or supposition about Rita's bad character isn't enough. I pause there and give one warning about this case, and that's that I think Nut and Rhea together are really pushing home this point that almost circumstantial evidence in these cases wasn't enough. Neither of them referred to the Schrader and Schrader quotation I went to, that you'll recall was where Mr. Justice Mann said, in these cases there often won't be direct evidence of undue influence, so you have to prove on circumstantial evidence usually. Obviously in these two cases, it sounds as though the evidence wasn't directly about the preparation and execution of the will, but was more a mudslinging match and trying to ruin someone's character to prove that they were such a bully the court should infer that there was undue influence. But I would just warn that I don't think that these cases should be treated as authority, that you need direct evidence of undue influence, because Schrader is still good law. Finally, the judge also said that the evidence of the solicitor showed that the deceased had acted of her own volition and her mind had not been poisoned by anyone. The only warning I give about this is that, of course, I think you could probably assess as a will drafter whether someone is being influenced or not, or at least to the extent possible in the way that you prepare the will. But if the mind has already been poisoned, it's hard, in my view, to see a situation where the solicitor or will drafter would be able to identify that, because of course the poisoning would have happened over a long period of time. And by the time, therefore, the deceased comes into the room, they are going to be very clear and emphatic about the terms of the will they want. And they will say, I want to remove X person because they've done all these terrible things. So it just seems to me that it must be quite difficult for a solicitor or will drafter to identify fraudulent calumny as opposed to undue influence. I'm galloping through this because I'm conscious of time, but I want to quickly do this last case. Because it's a fascinating case, particularly actually for testamentary capacity. Clitheroe and Bond is really quite recent this year. 3 children. Debs dies, one of the children, in 2009, and mum suffered from an affective disorder which included a complex grief reaction and depression, and that was held to have impaired her testamentary capacity. She made 2 wills, both benefiting John. The final one excluded the other daughter, Susan. And it was held regarding testamentary capacity that a symptom of the deceased's disorder was that she harboured insane delusions about Sue, which poisoned her mind against Sue. So, for example, that she was a spendthrift, that she'd stolen items. And there's some particularly sad aspects of this judgment about the events leading up to Deb's death, for which the deceased tended to blame Sue unfairly for. and the judge therefore found the wills were invalid because of testamentary capacity. But fraudulent calumny was also claimed, that John was actively involved in the preparation of the will, he was a principal beneficiary, he had obvious financial motive to ensure he received the estate, and that whilst the deceased was strong-willed, she was very vulnerable to suggestions about Sue's character because she was already harbouring all of these insane delusions about her. Further, there is no rational basis for some of the delusions. It must have been prompted by someone. But this wasn't enough in this case. The judge said that there is insufficient evidence here as what there is circumstantial. There is no direct evidence of John encouraging his mother's beliefs about Sue without regard as to whether they were true or not. And this case is very different to Nut and Nut and Rhea and Rhea, in that all of the circumstantial evidence here is to do with the execution and the preparation of the will. In fact, in terms of the preparation, there's evidence that John actually went into the solicitor's office with Mum's instructions in hand and said, make this will. And there's records on the file, I think it was the earlier will of the solicitor, saying, well, this isn't how we usually do things. So there were suspicious facts and circumstances here. But I think overall, throughout all of these cases, it's quite clear that when you're assessing the merits of one of these claims for a client, you really have to look quite objectively and analytically at all of the evidence around what's circumstantial, is there any direct evidence of the things we're alleging? If it's circumstantial, then what kind of circumstantial? Are we just raking up old family history and trying to paint a poor picture of this person? Or is this actually circumstantial evidence that's strong and to do with the preparation of the will, or with regards to fraudulent calumny and the poisoning of the mind? And then finally, this is my slide, which sets out some of the other recent cases that you might want to have a look at. And you can see that all of them have been unsuccessful on undue influence and fraudulent calumny.
Okay, so we've got one question. Maybe I'll bring you in on this, Sophia. It's what steps could be taken if a will is disputed, but the application for grant of common form is not progressing? For example, a delay in the probate registry due to a lack of requested information from the propounding executor. The question is the citation procedure appropriate? Should an action be commenced under Part 57, or should the disputing party wait for common grant? And I think this question is being asked from the perspective of the disputing party, because if you're the propounding executor, you should just get on with what you're doing. If you're the disputing party, I think the answer is fairly clear that in these circumstances, it seems like there's not a caveat in place. So if I were you, I'd be getting on with claim under Part 57. I don't think the citation procedure is appropriate where an application is already on foot. And I would definitely advise against waiting for the grant in common form, because the risk with that is the grant in common form will come, and then the executor might start dealing with the estate. And you certainly don't want to be incurring the costs of seeking urgent injunctive relief. That's a disastrous thing to happen. So in those circumstances, I'd be strongly inclined to say that if you want to dispute the will, bring a claim under Part 57. Any thoughts on that, Sophia?
No, I agree with that. It seems like if an application's already been made for the grant, you'll kind of be on the stage of being able to place a caveat. And I agree that citation's not really appropriate if an application's been made as well. So you've only really got one option left if you want to try and stall things in their tracks. As you say, even if you later revoked the grant, you're faced with a situation where various steps might have been taken in the administration already that you just simply can't unwind, or you're just going to have to incur the costs of having someone go in and try to get on top of everything that's been going on, which is all additional cost. So supposing that you do have a meritorious probate claim, then I think, yeah, that might be the only option left. I think we've got another one, haven't we?
Yes. Is there a way to obtain a copy of the caveat that has been lodged against the estate without first applying for probate? I think the answer to this is yes. I think you can ask the probate registry for it.
I think that's right.
But it does usually happen that people discover the caveats in place either because they're told by the caveator, or they apply for probate and the probate registry says no because of the caveat. But I'm pretty sure you can find out in advance if you want to. Limitation for claiming undue influence fraud. Do you want to deal with that one, Sophia?
Sure. So, well, you obviously don't want to leave these things too long at all, because there's going to be a late cheese problem on an equitable basis if you leave things well out of time. Having said that, there are cases where you see fraud claims, particularly things like forgery, that can be alleged many, many years after the event. So it's all going to very much come down to the facts and circumstances of the case. For example, if you've got a will that no one knew about for years because it had been concealed and the administration of the estate had been done secretively on the basis of what you think is an invalid will, well then you're going to have less of a problem than if you'd known about the will for a very long period of time and just hadn't done anything about it. So if you think there's a problem, it's best to be proactive and act sooner rather than later.
Yeah, but there is no specific limitation period. And one thing that can happen is where there's no grant at all. This might happen where, for instance, one spouse dies many years before the other. The first spouse, no one bothers getting a grant. But when the second spouse dies, the first spouse's will or absence of will becomes important. And if there's been no grant, then whenever a grant is sought, all of these arguments are in play, even if many years have passed.
That's right. And actually I have an example. I had a forgery case recently where the deceased had died over 10 years ago, and my client had actually administered on the basis of intestacy because she thought there was no will, and the other side suddenly produced a will, so 10 years after death, and then there was a dispute, and we said, well, we think that's a forgery. And there wasn't a limitation point taken by anyone. It was more an evidential thing that we were saying, well, this will is suspicious because you've sat on it for so long. So yeah, it's going to be quite fact sensitive depending on the case.
I think it mainly depends on whether there's a useful purpose to be achieved. I think there are cases where people have tried to attain grants and therefore these disputes have become live even decades after the person's death. But you need to persuade the court that this is something it ought to be doing. Another question for you, I think, from Zach. And thank you, Emily.
Oh yeah, thank you to everyone that's offered questions. Is it possible to change a will for undue influence where the testator is still alive, where one beneficiary has disinherited in a new will and has become aware prior to the testator's death? So no, I don't think you can challenge the validity of a will after someone's died, because of course there's always the possibility that they're going to revoke it. Wills are inherently revocable, and a person is free to change the will as they like. But this is actually one of the practical problems. This is the reality to probate claims, isn't it? And undue influence, that often you can see things going on at the time that are concerning or suspicious. I don't think there's any one set of advice that can be given about this situation, only that it probably is best for someone to seek advice if they think that particularly an elderly person is being subjected to undue influence. But of course, all of the facts surrounding the making of the will become relevant if there is a probate claim. And some of the cases that we've looked through today, I think, show that the way that people have behaved towards the testator during the lifetime around the execution of the will can become very relevant to the probate claim. Whoever it is that's been disinherited, I think, probably needs to be thinking very carefully about how they conduct themselves now and the type of steps that are taken. Something that often goes hand in hand with this as well, particularly if you're dealing with an elderly testator, is concern about their current set of finances. And we kind of saw this in the first case that I spoke about, Krista Dooladies. You can often find that if you think there's undue influence, it usually goes hand in hand with control over financial affairs, becoming someone's attorney and that kind of thing.
Yes, I agree. You can't commence proceedings before the person's died, not probate proceedings at any rate. But you can gather evidence. That's something you can do.
I think you just need to tread carefully and make sure that at all times you're seeming to be as objective and reasonable in your investigation as possible, because you don't want it to appear that you've been, all of your actions, I suppose I'm saying, are probably going to be subject to the evidence if there is an ultimate contentious probate claim.
What often happens, of course, is people try and influence the testator back to doing something else.
We need to be careful not to be seen to be doing that. That's basically what I'm trying to say. You don't want to look like you're the undue influencer if suddenly there's a new will made out that adds you back in again.
But not uncommon.
You just need to tread carefully, I think.
Okay, well, unless there are any other questions, thank you again, everybody.